Good day, Thomas Jefferson Hour podcast listeners. And as always, thank you so much for listening.
We're glad you're with us today. Really a remarkable program, David. We received out of the blue a letter from a prisoner in one of our systems, one of our penal systems. And also I received a letter from his mother. She passed on questions that her son had, that he'd written in prison, that he'd like Thomas Jefferson to address. And I was delighted by this, the idea that someone in a prison somehow has access to the Thomas Jefferson Hour and took the time to want Mr. Jefferson to weigh in on certain judicial questions. I just think there's something magnificent about that and really redemptive. And so it moved me deeply. And so today we take his questions. You put most of them, not all of them, to me, and Mr. Jefferson answered them. But my friend Lynn Novick, Lynn Novick of the Ken Burns world.
I don't know her, but I certainly know of her.
She's an amazing human being. She truly a genius, and she.
Well, tell people who she is.
Well, she's Ken Burns' partner. She produced baseball. She produced a lot of jazz. She did most of Vietnam. So he's the great Ken Burns, but he works with an extraordinary team, and his longtime professional partner has been Lynn Novick, and she and I are friends. And we met in fact in Walpole, New Hampshire, at a Burns project. And she has a documentary about prison college in New York State, and how when college humanities courses or math or whatever are taken into the prisons, it's surprising how many really extraordinary students there are in prisons. They might be people who have committed a terrible crime in one zone of life, but they're still readers of books and thinkers about life. And B, that these courses, David, have a rehabilitory effect in many cases. They help people gain a sense of themselves, to contextualize their lives and their crimes, to see a path out, to learn some intellectual skills, to learn how to write, to learn how to argue, to immerse themselves in the deep tradition of the humanities, and it helps them to understand human nature and where their own lives have gone right and wrong. It's absolutely extraordinary. You can find her documentary just by typing her name, Lynn Novick, in Prison College. But when I was living in Boulder, Colorado, I worked with some prison folks in Colorado Springs. It was not a state prison, it was a jail. And they actually had their inmates gardening. And the gardening was really extraordinary. And it changed people's lives, that they had to think, well, we got to water the beans. We've got to weed the corn. We have to make sure that. And so these prisoners had a prison garden, and it created some extraordinarily harmonious, peaceful conditions to put their hands in the soil and do something that's fundamentally and obviously meaningful. And I just thought you would think that's like the greatest idea ever.
Yeah, I noticed that in the conversation. It was great, yeah.
So anyway, that's our program today. Then I want to say, too, that this course I'm going to be teaching, this online course on the Constitution 101 and how we would amend the Constitution and what the problem spots are in the U.S. Constitution and where we're headed and where we are in what is now, of course, a serious constitutional crisis. But it's not about current events. It's really about a deeper examination of the Constitution and its and how things stand in the third decade of the 21st century. So that course, people can sign up at jeffersonhour.com. And also, we're doing a second unprecedented course on J. Robert Oppenheimer and the decision to use the atomic bomb. I just, in fact, spent the weekend reading the great Kai Bird and William Sherman biography of J. Robert Oppenheimer, and I can't wait for that. So that's January 24th through 28th, so people can go to the Jefferson Hour site to see that, and there are books for sale, and it's just a great time for me, David, in my productive life, because I've been sheltering in place. I haven't seen you. When's the last time? I mean, we've had a couple of drive-bys.
Yeah, a little drive-by in
but
the
when's the
alley,
last time I sat in
things,
your
get your
studio?
mail
It
sort
was
of stuff, yeah.
Wasn't it March the last time I sat in studio?
Yeah. Actually, I think we're sort of settled into this. It's working quite well.
I love this, actually.
You have a couple of great microphones and a setup at your house. I keep telling you should give me those mics. They're terrific.
I'll happily barter with you. So yes,
Well, I think all things considered, you should hang on to
I
it
have
for
a
the
home
time being.
studio, and here's the thing. I mean, I love coming to the barn to work with you.
Yeah.
For the same reasons I love the idea of prison gardens, but this has been very convenient so that if we're going to do a program, I can be in my bathrobe or I can be in jeans. I can be in my Jefferson wig and tights. I can, we can do this.
You're always in your Jefferson wig and tights when you're doing Jefferson, aren't you?
Absolutely. So it's really created a flexibility that, and then of course, what's the big gift of the pandemic? Dr. Joseph Ellis.
Yeah, the friendship that has developed between you and he and I it's really great. I mean, it is a bonus to what's going on with the pandemic. But to listen to the two of you banter back and forth about all of the historical knowledge that the two of you have charted away in your minds it's great, and I always enjoy those conversations.
I want to do
very
more
much.
interviews with Joe, and there are other historians that are contacting us now, as you know, that are eager to be on the program, and I want to interview John Meacham, and there are a number of other people that I want us to interview on this. Before we go to the show, I just want to go back to the case in 1770 of Howell versus Netherland, the case of young Samuel Howell. Who was mixed blood.
The one thing that Jefferson said today that I should have called him on, but I didn't want to get sidetracked because we had all these questions, was in connection with that case, him talking about how people were born free. And of course, I wanted to say, well, what about those that were born at Monticello, Mr. Jefferson?
Well, there is that.
He just put that away.
But you see, this is kind of the Joseph Ellis point, and I agree with it. I don't think it's Pollyanna. His view is that in 1770, Jefferson was like ready to do the right thing and get this thing over with once and for all for Americans. So he took this case in part to sort of test the waters. And so he made this argument, which we all think is absolutely fundamental, that all men are born free. And he, in his own telling of the story, he barely got that sentence out of his mouth before the case was dismissed and Howell was thrown back into slavery. And so he's getting his fingers burned and he's saying, whoa, the blowback is gigantic. Now, I don't want to defend him, David. I don't ever want to be in the case of defending Jefferson and slavery, but you can see what he was up against, that he was facing a world that was mostly hostile. I mean, openly hostile to the point that he was trying to establish. And so I think what happened was that he had some setbacks early, and then
tried and failed.
And then he thought, well, time is on our side. But as he went on in life, here's where I become disappointed. There was a hardening of his spiritual arteries until he became indistinguishable in many respects from any other Southern plantation owner. And that's not the Jefferson I most love. But at this point in 1770, I mean, just think of this. All men are born free, and everyone comes into the world with a right to his own person and using it at his own will. And if you think that poor Samuel Howell, grandmother white, grandfather black, mother mixed blood, he mostly white, legally a slave, and Jefferson's view is, how can a human being, through no fault of his own, be born a slave? Now, that mirror has to be turned back on Jefferson, of course, but how can a human being, through no fault of his own, born accidentally into the world, be born a slave? That was the question. And at that point in 1770, Jefferson knew the answer. Whether he still knew that answer in 1820, I think is an open and sad question.
There's so many levels to that. As you said, he opened his mouth with that argument and was almost immediately dismissed. I mean, the laws in Virginia and much of the South at that time, you couldn't legally free a slave.
That's correct.
I mean, it was against the law. There was no place for him to go.
They were required after 1808 to leave the state forever. I mean, this creates an impossible problem for any human community. And so you had to get special legal protection from the courts to free any slave whatsoever. And Jefferson tried to open that and say, no, under certain conditions, slave owners should be allowed to manumit their slaves, and this should be acceptable. And the House of Delegates in Virginia slammed the door as hard as they could in the face of that and said, no, never.
Boy, that would be an interesting subject of conversation. I'd like to go through the whole history of that, but I think probably better what we should do is go to this week's show, sir.
I want to thank this gentleman. I want to thank his mother. I want to look more into this. It's all really interesting to me, and I appreciate you, David, being wanting to do this equally. And I think it's a really important program. And I would urge people from all over the country, no matter what your walk of life is, if you're interested in the Jefferson Hour, to send us mail, email, or otherwise. And we're always glad to hear from you. As you like to say, David, we read every piece of it, and it matters greatly. And I know that I sound emotional about this, but I was just terribly moved to get this letter from the mother and the son. And I just felt this is what we should be doing. This is actual community service, reaching across all of these metal bars to talk with somebody who happens to be incarcerated, and we don't know the circumstances of that, but we know he's an interesting and intelligent human being.
So thank you, sir. And I must mention before we go, if you enjoy the program, rest assured we're going to keep doing this under whatever circumstances are dealt to us. But we can always use your support. Clay and I don't take anything for doing the show, but we need to get it up on the air, and other things cost. So if you are of a mind and means to support the Jefferson Hour, we so appreciate it. Just go to jeffersonhour.com and click on donate. And with that, let's go to this week's show. Good day, citizens, and welcome to the Thomas Jefferson Hour, your weekly conversation with President Thomas Jefferson. Mr. Jefferson is portrayed by the award-winning humanities scholar and author, Clay Jenkinson. I'm your host, David Swenson, and good day to you, Mr. Jefferson.
Good day to you, citizen.
Mr. Jefferson, we've got an interesting set of questions presented to us by an incarcerated person that I want to get to. But before we go there, sir, forgive me, but you accomplished so much in so many fields that we often overlook your personal history as a lawyer. In Virginia's early history, there were no established law colleges. In fact, during the 1600s, citizens of Virginia could call themselves lawyers with very little training at all. How did you study the law, Mr. Jefferson?
Well, you are correct that there were no law schools when I was educating myself in Virginia. I helped to create the first law school in Virginia at the College of William and Mary, but that wasn't until I became the governor of the Commonwealth. I read for the law as, I suppose, an apprentice with a brilliant man named George Wythe, who was one of my mentors, and I studied under his tutelage for almost 5 years before I took the bar exam. I was examined by 3 of my fellow Virginians in 1765, and then I had a law license. By my time, that was required, and I practiced law from 1765 until the time of the Revolution. So from 1765 until 1774. That was the end of it, because the Revolution closed the law courts, and once they reopened after the war, I had effectively moved on into another phase of my life. And although I continued to have the capacity to serve as a lawyer and was very glad to have the training in the law that I had had with George Wythe, I never again practiced law in a court.
A knowledge of law in the English tradition was really the mark of an educated Virginia gentleman, was it not?
Well, some. So, most Virginians had a smattering of higher education, men, I mean, white men. And in a sense, they learned a few important skills, and the college was a networking situation for them and a place for them to get a certain kind of social polish between their youth and their full adulthood. But most Virginians did not take higher education very seriously. But those who wanted to have a life as a professional, not just as a planter, would either go into the clergy, and William and Mary was essentially set up for that purpose originally, or they would go into medicine. That usually required them to study in Europe, Scotland, or in the Low Countries, or they would go into the law. And although I'm not always fond of the law, I see it as a fundamental preparation for statesmanship, that anyone who has any interest in serving in the state as a political figure, as a representative, at the local or national or state level would do well to study the law, because it teaches you how to draft legislation, for one thing, but it also gives you some sense of the long tradition of the law that dates back in the European world to ancient Rome and possibly beyond. And so to know all that gives you an indispensable foundation for crafting laws for your own time.
Many of your early cases had to do with issues of land, but there was one case that I found of particular interest I hoped you could briefly comment on. It occurred in April of 1770. It was Howell versus Netherland, a case which was argued before the General Court of Virginia. You acted as attorney pro bono on behalf of Samuel Howell, a mixed-race man being held as an indentured servant because his grandmother was white and his grandfather black, and you argued that, quote, not only had Howell's grandmother been a white woman, but under the law of nature, all men are born free.
Yes, so I took the case, as you rightly say, pro bono. I lost, by the way. The case was summarily thrown out after I made my argument. My argument offended the legal establishment of Virginia. I argued against my old mentor and one of my dearest friends, George Wythe, and he won the case handily, let me say. But I took it because I felt that natural law, the law that's deeply written into the human heart, the laws of basic fairness and equity, had been violated by positive law. Positive law is the laws that humans, with all their imperfections, pass in assembly. And so the Virginia law that attended to this situation said that if your mother was a slave, you were, by that very fact, a slave. So here was Samuel Howell, whose grandmother, 2 generations back, had been a white woman, and she had gotten pregnant by a black man, a slave. And for that, she was severely rebuked. And because she was a white woman who had had sexual congress with a black man, her children were enslaved. And then her children's children were enslaved. So here was Samuel Howell, who's born innocently into the world. He had no role in his conception or the conception of his parents. And according to the law code of Virginia, he's not a free man, but a slave. That seemed to me to outrage any notion of basic justice. And so I took the case, and in the argument that I made, I said all men are born free, and everyone comes into the world with a right to his own person and using it at his own will. This is what is called personal liberty, and is given him by the author of nature because it is necessary for his own sustenance. This was the first time I invoked the phrase, we are born free, all men are born free, and everyone comes into the world with a right to his own person. It was perhaps a principle of natural law, of the law of basic justice, but it was not a recognized principle in the Virginia law code. And so the case was quickly settled unfavorably to Mr. Howell, and he was returned into a state of slavery. I should tell you before we move on that I revised the entire law code in the Commonwealth of Virginia. After writing the Declaration of Independence, I went back from Philadelphia to my home, and there I was put on a committee of several to revise the entire law code to bring it into harmony with our Republican system of values. And I did the bulk of the work because the other participants yielded to me and had other things going on in their lives. And in that revisal, which was the hardest intellectual challenge of my entire life, 4 long years revising every single law that we had inherited from the British common law tradition and from the codes, the actual legislative codes in our own colonial system. I attended in that revisal to the laws of crime and punishment, and there I was able to bring about some significant reforms along the lines of the Italian humanist Cesare Beccaria, whose treatise on crimes and punishment, published in 1764, just published that is, was extraordinarily influential all over the world. Dr. Franklin found it remarkable and useful, and so did I. And there are, in fact, a great number of quotations from Beccaria's a treatise on crimes and punishment in my literary commonplace book, a sort of scrapbook where I put passages from books that I greatly admired.
Thank you, sir. Let's move on to these inquiries from this incarcerated person. The first question, sir, centers around what the founders thought when they set the burden of proof in criminal trials at beyond a reasonable doubt. What exactly did they intend when they said a jury's doubt must be beyond reasonable in order to convict? Did they mean to a moral certainty? What exactly did they mean and why?
Well, that's how the law works. So that's a tradition that wasn't invented in the United States. That's a tradition that goes well back in British history. And so someone is accused of a crime. That person is entitled to be represented by an attorney. The state presents its case and says, in our opinion, this person broke into this house and stole furniture, and we intend to prove it in the course of this trial. And then the defense attorney says, well, that's what things look like. I mean, there's certainly, it appears that my client may have committed this crime, but I intend to show you that he didn't. And I believe that when this is over, you will have significant doubt. And if there is reasonable doubt, then the jury should find for the defendant. But if they think, well, we have a touch of doubt, but really it looks really overwhelming that this person committed this crime, then they should return a verdict of guilty. So that's it's I can't define it in a term that would find universal agreement, because of course that's the nature of it. I mean, when the jury gets behind those closed doors, someone might say, it just doesn't smell right to me. It just doesn't. It looks bad, but I can't see that. Here are a couple of facts that don't quite fit in this narrative, and so that debate goes on until the jury reaches its conclusion, and so that's the American standard, that you are guilty, but only if a jury can declare your guilt beyond a reasonable level of doubt about it.
So those two phrases, reasonable doubt and moral certainty, well, they leave room for error. Would you say so, Mr. Jefferson?
Of course, but one of the great breakthroughs in our system in the United States is trial by jury of one's peers. For most of human history, people have been tried by the state, by prosecutors, by judges, by people who are committed to the order of the state. And we felt strongly, I mean, this has its roots back in the British common law tradition too, but we felt strongly that a person is entitled to be tried by a jury of his actual peers. So during the run-up to the Revolution, Americans who were guilty or who were deemed to be guilty of certain crimes were carried all the way across the Atlantic Ocean to London to be tried by aristocrats or judges that they never met and who had no experience with America. We insisted that they must be tried by their own people, by people much like themselves, so that it's not people that knew them, but people who are neighborly in some broader sense of the term, people who have like experiences in life, and that jury of one's peers, especially if it proliferates into more than one juror, is going to be able to sift most questions out, and most cases do end in a unanimous verdict by the jury. So that's a safety provision that prevents one prejudiced juror or judge or prosecutor from carrying all the weight in a trial that may involve a person's freedom.
Thank you, Mr. Jefferson. We need to take a short break, but we'll return to this conversation in just a moment. You're listening to the Thomas Jefferson Hour. Welcome back to the Thomas Jefferson Hour, your weekly conversation with President Thomas Jefferson. Welcome back, sir. We've been discussing a series of questions sent to you, Mr. Jefferson, by an incarcerated person, and in our previous segment, you sort of answered the next question, which has to do with the Sixth Amendment, the right to a trial by jury in criminal trials. And the question is, was it for the jury to act as a bulwark against tyranny?
Yes, because so often in the previous history of the law, the deck was stacked against the accused For a long period, he didn't have any right to representation at all. So this poor person accused of a crime he may or may not have committed is hauled into court, where he's treated in a hostile way, possibly having spent some time in a deplorable jail and maybe roughed up by constables, and suddenly he's hauled into court to a world that he's completely foreign to, accused of a crime he may or may not have committed, and thrust upon the witness stand. And when it's over, the judge says, well, I think you're guilty, and I'm going to punish you by the following sentence. That has been the rule in human legal systems for most of human history. The British had begun to create a better system after the Magna Carta, but particularly in the 17th and 18th centuries. And so that's a hallowed and important British legal tradition, and we took it further here in the United States. So we insist, by the Bill of Rights, by one of the amendments to the Constitution, one of the first 10 and most important of all amendments, that a person accused of a crime has a right to representation, and he is to be tried in a court of criminal law with a jury of his peers, of people who come from roughly similar circumstances in life.
The next question deals with the necessity defense, which I believe dates back to 1884. Do you believe a person should be found innocent due to mitigating factors for a crime if it was specifically done to evade an imminent and credible threat to one's life, much like how self-defense allows one to be found innocent of murder for the same reasoning? Would the founders place money above life?
These are hard questions, so this will vary from case to case and judge to judge and situation to situation, and there's no single and hard and fast rule that can govern all of this. This is what we mean by common law. So it's one thing to have a law that says if you shoot somebody else's pig, you must pay a fine of $500. That's clear cut. Now, there may be ambiguity about whose pig it is and under what circumstances it was shot and so on, but we all think in our sort of civics classes about a world in which there are open and shut cases where everything is very clear. But that is seldom the case. And so to apply these notions of cruel and unusual punishment and the laws of necessity and self-defense and under what circumstances we can show violence to an intruder or someone that we perceive to be an intruder, these turn out to be very complex, very nuanced, hard to settle. And so what happens is that a court of law in Buckinghamshire in England decides a case of this sort in one way, and a court of law in Lincolnshire decides it in a slightly different way. And over time, these cases have a way of building a body to clarify the nature of the law. And so it's that accumulation of a body of decisions over time that refines and clarifies the terms in legislation and the range of circumstances which might cause one to rethink certain legal provisions. That's what's known as the common law. And so my goal was to codify the law to the maximum extent possible so that it was simple and easy to understand, and to limit the amount of the range of these things. But you can never fully emancipate yourself from this. So yes, of course, there are times when to protect one's life and one's family, someone needs to do something that under other circumstances would be considered a crime. And then the legal representative will try to show the judge and the jury that these are extenuating circumstances. And then the jury, after hearing the facts from as offered by both sides, will sequester itself and try to sort it out and come up with the best solution that they possibly can. They will sometimes go wrong, either because of poor representation or because the facts just don't lend themselves to a clear answer. But more often than not, the jury will sort things out really well. I have great respect for juries because they may not be brilliant legal theorists, and they aren't supposed to be, but they often have very good common sense. They usually do, and they are rightly skeptical of arguments that are not based in evidence.
The next question, Mr. Jefferson, what did the founders mean by infamous crime in the Fifth Amendment?
That was James Madison who wrote the Bill of Rights, and he was really working from, again, the common law tradition. In other words, this was not an original concept. This was something that he was incorporating from the long tradition of Anglo-American common law. And an infamous crime is one that is a felony involving moral turpitude of such a strong nature that it creates the presumption that the person guilty is not even worthy of a court of law. In other words, it's so palpable, so obvious, so filled with deceit, fraud, or corruption that it truly is an open and shut case. And so this is a tradition that goes back into British history.
The next question, Mr. Jefferson, what do you think of people being routinely held with no trial for a period of perhaps years?
Now, that would violate the law of habeas corpus. So one of the greatest provisions of the United States Constitution, it's so important it's not even delayed until the Bill of Rights, is a prohibition on violating habeas corpus. And habeas corpus is a Latin term. It comes from the subjunctive sense of it. It means let us see the body or hand over the person. You can't put a person in jail and slam the door and not let the world know that you have that person. You have to admit that the person is under custody, and that person needs to be capable of being brought forward into the open court so that the community can see that that person is alive and healthy and know that the proper procedures are being used in the system of incarceration. That may seem obvious in your era, but it wasn't obvious in most of European history. So someone would be accused of a crime and thrown into a dungeon or to some sort of a prison and never seen again. And nobody would know what happened to person X or person Y because there may not be any paper trail. The family and friends may not have been notified, and therefore a person would simply disappear into the judicial system and never emerge. And so habeas corpus dates back to the Magna Carta also in the 13th century. And what it means is that you have to be able to prove that the person is still alive and well, and you have to be able to exhibit that person in his own body, walking on his own legs into a court. And so this is absolutely a fundamental part of the legal system. So if someone is jailed for more than a short time and nobody else knows about it, that is a violation of the principle of habeas corpus. And every jurisdiction, every state has its own definition of how soon that person must be produced or capable of being produced in order to pass that constitutional test. But my point is that this is so very important. This is one of the handful of most fundamental provisions of a just legal system, that it goes right into the body of the Constitution of the United States itself. It does not come up in the aftermath by way of the Bill of Rights.
According to the questioner, 95% of all convictions in the United States are achieved through plea deals. Assuming that's correct, what do you think of a justice system of plea deals and not trials?
Well, the legal system, the judicial system, would be clogged to the point of being immobilized if every case came to trial. You could never afford to pay for a legal system lavish enough and with enough human resources to try every single case that comes up. So if I'm accused of a crime, let's say I'm accused of shooting my neighbor's pig, and this is probably headed towards court, my attorney and the other person's attorney will sit down and try to find a compromise. And the prosecutor, operating on behalf of the county or the state, will say to me, look, Mr. Jefferson, the evidence is really strong. You're going to be convicted. If you will just confess, if you will plead guilty here, we can lighten the punishment somewhat, because by cooperating with the legal system, you're showing that you have fundamental respect for it, and therefore we will make your sentence less onerous than it will be if you continue to deny that you committed a crime that you quite clearly have committed. And then I get to decide whether I want to go to trial or I want to accept that plea bargain, and my attorney and the state argue back and forth about it until they come up with a compromise that my attorney and his client, in this case me, is willing to accept. So yes, I'm entirely in favor of that. But here's one of the problems with it, sir. Many times the prosecutors dangle extraordinary possibilities of punishment in front of somebody to coerce them into pleading guilty. And so it's the severity, it's the the gravity of the sentence that's being dangled in front of the accused that often persuades them to admit to a crime that they may actually not have committed, but they are so frightened of what could happen if they were convicted in the court of law that they wind up pleading guilty. And maybe they're guilty, but oftentimes they aren't, and they just fear the severity of the punishment that's being used to coerce them. And so it seems to me that there should be as little actual coercion as possible in plea bargaining.
The next question deals with the abundance of police we have today and asks that you comment on the fact that there really were no police during your time, or no police force.
Yes, in the ancient Roman world, there were no police, and so it worked essentially by citizen's arrest. I mean, people had private security teams, but I would come up to somebody that had committed a crime, or that I thought had, and I would say, I arrest you on behalf of the legal system of Rome, and I would have to have my own security team to be able to do that, because otherwise the person would say, forget it, I'm not going to be arrested today. And so this is a very inefficient system. Fortunately, in the British system, beginning in the Middle Ages, but certainly in the era of modernity, we began to have night watchmen who became constables, and there were sheriffs in the British counties. And so a system of actual formal representatives of the legal system of the state began to emerge, and modern police forces were being born in my era, although they were still quite rare in my time. It's not as if there weren't officers of the law in a place like Charlottesville or Albemarle County. I was a justice of the peace. My father was a justice of the peace. And there would be court functionaries who performed some of these arrests and served papers. But it was much, much less formal and organized in my era than it is in yours. By the end of the 19th century, so at the beginning of the 20th century, almost every jurisdiction in the United States had a significant force of actual trained policemen. But that the questioner is certainly right that was a much more shadowy system, and not really a system at all in my time.
Currently, about 0.7% of the United States population is incarcerated, and this is one of the highest incarceration rates in the world. Do you have any thoughts on this, Mr. Jefferson?
Well, I don't know what that signifies, but whatever it signifies is sad. In other words, if you dream of a society, you want to live in one in which there's almost no crime. And those few people who are either mentally defective or who have been severely damaged by life, or who are just evil, if that's a category worth considering, that number of people would be exceedingly small, and we would have a system to handle those acts of antisocial behavior. But the idea that any significant portion of the population is in prison is deeply saddening to me. Now, if you look at this from a sociological point of view, you will find that most crime is economic crime. In other words, if you took all the prisoners out of the prison system in the United States who had committed crimes out of economic desperation or perceived economic desperation, that would reduce the number of prisoners enormously. So the criminals who have done just unspeakable things, who have raped, who have tortured, who have committed acts of violence against others, who have murdered people, that's actually a fairly small portion of the overall prison population. And so if you had economic justice in the United States and every human being had a roughly equal chance at modest subsistence, if they were willing to work, of course, then I think your prison population would be much diminished. And so if you just all try to remember that most crime is economic crime, not crimes of a hateful soul, that changes the way you think about it quite considerably. And we all must strive for a nation in which there is sufficient economic activity for everyone who's willing to work, that people do not feel so desperate that they commit economic crimes.
Mr. Jefferson, the questioner wants to know if you would consider our current state of affairs in American criminal justice a threat in any way to our democracy?
I can't answer that question. The earth belongs to the living and not the dead. I've already said that if you have any significant percentage of your population that's behind bars, that is a very severe indictment of your social system, because you really have to ask yourself how many people out of 1,000 or 100,000 are just incapable of behaving in a lawful way. I mean, what percentage of people, no matter how you educate them or what you try to do, is just a criminal class, and that the only way to handle it is to sequester them from the rest of the community? I dare say that's a very tiny percentage of any society. And so your prison population is a measure of what's wrong with your culture. It also, of course, is a measure of those people who are truly antisocial. And so I would hope that the people of the United States would work hard to build a just and equitable society and to educate everybody up to the point of their capacity. And then I think you would find that your prisons would be emptied out. So, in one's dreams, there are no prisons at all. And that's obviously a naive way to look at it. But I do think that in a real republic, you would have a very small prison population. And let me just go a little bit farther with that. I think a rural population is, on the whole, going to be a more law-abiding and socially harmonious society than an urban population. Urban culture creates a criminal class. It creates a class of unemployed and unemployable people. The food distribution, the claustrophobia of cities, the spread of disease in cities, these things create a kind of a congestion, not only of the zoning grid, but they create a congestion of the heart and the soul and the spirit. So I prefer rural America to urban America in that respect. And I also think that people who are associated with agriculture, people who have their hands in the soil, are much more likely to be good citizens, people of harmony and peace, than people who have no access to nature with a capital N. And I do note that many prisons experiment with gardens for their inmates, and those gardens tend to produce a much more harmonious prison population and one more likely to build rehabilitation than those that refuse to engage in that simple business of allowing a prisoner to grow a bean or an ear of corn or a tomato.
Mr. Jefferson, on behalf of this questioner and myself and your listeners, I thank you very much for taking the time to answer these questions.
You're most welcome, and may I say to the prisoner, wherever he is, that we very much appreciate his questions, and that these are questions of great importance, and I think that bodes well for him and for others.
Thank you, Mr. Jefferson. We're going to take a short break, and when we return, we'll be joined by the gentleman who portrays President Thomas Jefferson, the creator of the Thomas Jefferson Hour, Mr. Clay Jenkinson. We'll be back in just a moment.
Welcome back to this special edition of the Thomas Jefferson Hour. I'm Clay Jenkinson, now safely out of wig and tights, and seated across from me, at least virtually, is my very dear friend, David Swenson, the semi-permanent guest host of the Thomas Jefferson Hour. David, great to not see you, but to hear you.
A great series of questions, and I was very impressed with how generous you were to want to put this in the front of the queue and answer these questions from this incarcerated person.
This really delights and intrigues me, David, because first of all, I've done a lot of prison gigs in the course of my career. You'll hear a little bit more about that in my essay today. But I also, as you know, we get correspondence from people in prisons and jails quite frequently at the Jefferson Hour. And here's what's so interesting about it. First of all, that they took the time to write, and there's an infrastructure that allows them to actually send a physical letter through the U.S. mail system. I like that. They often report that they've been doing a lot of reading in the prison library, and that, of course, can only please anyone who cares about the humanities and education. They often represent themselves in habeas corpus matters, or to try to get their case reopened for some reason or other. And so they have to learn a fair amount about the law. And there are cases, I know a great amount about the Ninth Circuit Court of Appeals, because my former wife, Etta, was a clerk in that system for a number of years. And a lot of these prisoners become really superb amateur legal scholars and produce outstanding memos and filings for the court system. And then finally, it just seems to me that if someone is listening to the Thomas Jefferson Hour in whatever way, and it's helping them, and we get a lot of that testimony, that prisoners are pleased, are satisfied, are inspired in some way by the discourse on the Thomas Jefferson Hour, I just find that to be, deeply moving to me and deeply satisfying. So I pushed for us to, as you say, move this gentleman's questions from the front of the queue. I don't know what he's accused of, and I don't know whether he's guilty or innocent. That's none of our business, really. But what is our business is that someone from inside a prison facility reached out to us across those barriers and asked some very good questions about our judicial system.
There is one question that we did not get to with President Jefferson. I'm going to present it to you now, sir. The question I didn't get to was, how crucial would you say the jury upholding the burden of proof is to maintaining our democracy?
Very much, if I understand the question right. In other words, there was a previous question about reasonable doubt. So our system is wonderful in that we say that a person is innocent until proved to be guilty. So there's a presumption of innocence in our system. And you don't always feel that when you look at the system, either through films or television or what one reads in the New York Times. But that's our principle, that you are innocent until our formal legal system can prove to the satisfaction of 12 jurors that you have in fact committed the crime in question. So that's important. And I think that what he's getting at is that jury systems, public attorneys, judges, bailiffs, the whole system is pretty jaded, as I suppose it has to be. And they often see people and they just assume, well, of course he's guilty. That's just obviously this one's going to be an easy one. And that's a form of profiling, what the person looks like, tattoos, facial qualities, demeanor, race, of course, and gender. And so I think that we don't have a colorblind system. Lady Justice is seen as blind, holding the scales of justice in her hand. We know that's wrong. We know that's not always the case. I think that's the most charitable way to put it. Jefferson actually believed that juries should, under certain circumstances, nullify a verdict because they feel that there are extenuating circumstances, or that there's some other reason. Maybe the law is unjust, at least as it applies to this situation. And so he wanted juries to have that power. Most judges find that to be a really horrific doctrine.
There's one thing that I would go back to the beginning of the conversation that really struck me, and that's Jefferson studying the law. It affected him, his study of the law, his thought patterns, and what he did throughout his life. Wouldn't you say that's accurate?
Yes, very much, David. I'm going to be doing this online course on the Constitution and the future of the Constitution beginning in early November, right after the election, so people can go to the Jefferson Hour site to see that. But I'm really excited about it for this reason. On the first session, we're going to create a state of nature. We're going to say, let's say there are 30 of us or 25 of us. We're going to say, all right, everything broke down. We're now living in a state of nature. We're now going to constitute a society. And then we're going to have an open discussion. What do we need? And someone's going to say, well, we need roads, don't we? And somebody else is going to say, well, we have to have schools. And someone's going to say, we need a fire department, and so on. And so you're going to build a system because people are going to perceive what the actual social needs, the basic Maslowian social needs are. And of course, I did this with a friend of mine a couple of weeks ago as sort of a practice run. And the first thing she said was, well, of course you need a system of crimes and punishments. And so this online course on the Constitution, how well it's holding up, what the weaknesses or flashpoints are, what sort of reforms or amendments are being brooded about and proposed, how well it's holding up to protect our republic. clauses about war powers and the emoluments and impeachment and separation of powers and so on. But what we're going to do to start, David, is to talk about what has to go into any constitution of a people living on an island, or the people living in a republic, or people living in a mass democracy like our own. And it is certainly the case that if we were starting over, we would probably design a somewhat different system from the one that we have inherited. And the questions that this man has asked are really important questions. And there are others that we didn't get to, like what is surveillance? Privacy is going to be a very contested ideal in the 21st century and is being eroded as we speak. So I think this was really a good program, and I really appreciate our having a chance to talk about this. Jefferson was a good lawyer, and he's in contrast with Patrick Henry. Patrick Henry was not a scholar lawyer. He was the kind who's just magnificent on his feet in a courtroom. And Jefferson didn't have that capacity. He knew that he wasn't a good orator and that he wasn't the kind who could bend a jury to his charms as a legal advocate. But he admired that quality in Patrick Henry, but he knew he didn't have it in himself. And that's why he did mostly real estate, land law, about people's titles to land, especially beyond the settlements of Williamsburg and Richmond.
Well, I'm glad you brought up your online course. In the few moments we have before we go to your essay, could you quickly summarize some of that, what's coming up and where people can find out more about it?
I'm just finishing an online course on the Homeric epics, and now I'm going to do this one. I hope to fill a couple of sections because it's so important, and that is partly Constitution 101, how many people have actually read and studied the Constitution, but it's also what are the things that we would want to address if we were rewriting it. I mean, the Second Amendment was written for an age of muskets. Is that something we need to attend to? Separation of church and state. Lots of people think that that's been sort of distorted by the courts of the 20th century. One of the issues that I'm most interested in is the war powers. The war powers are meant to be done in the House of Representatives. And so, where are the points in the Constitution where it's able to actually shape and channelize the will of the American people? And where are the points in the Constitution that, for whatever reason, changes in technology, changes in the pace of the world, changes in the level of mayhem that's out there have morphed into something that's not strictly what the Founding Fathers intended? And then we're going to look at a couple of books, including Larry Sabato's book. He's a distinguished professor in Virginia, and he has a book about constitutional changes that we need to make. And then finally, we're going to read a book that I really admire called Are We Rome? And the question that book raises is, are we going down the same really ruinous path as Rome did when it ceased to be a republic? The course it'll be fascinating to talk about what is a constitution, how did we get our constitution, how well is our constitution doing if we amended it, if we tried to rethink it, what would be the places that we would inevitably have to focus on to clarify what the Founding Fathers meant or what we now mean.
People that are interested can go to jeffersonhour.com and find out more information on all of these online courses that you've done and are planning to do. And with that, sir, I thank you for an enlightening conversation and Mr. Jefferson. And it is now time for this week's Jefferson Watch.
Thank you, David. I've done my share of prison gigs in the course of my long, strange career. I remember once giving a prison talk at a medium security facility in Colorado. My friend Quentin and I arrived at the right time and went through a whole series of security gates before we got to the place where I was to give the talk as Thomas Jefferson. I don't much like the theatrical side of portraying Thomas Jefferson, even under the best of circumstances, the costume and the wig and the buckled shoes. But it really feels odd in a place where several hundred men have been locked up for grievous crimes against the public order. We had to go through at least 3 checkpoints, and each time, once we had been buzzed through, we heard behind us the clang of the heavy steel gate locking us inside. We knew we were guests of the institution, but it makes you immediately review all the crimes you have ever committed or wanted to, and it is truly a very uncomfortable feeling. And then, of course, you face people who have so violated the social compact that they have had to be locked up, and this from a person wearing tights and buckled shoes. Lately, I have been working on a script for a dialogue between Mr. Jefferson and the Italian reformer Cesare Beccaria, 1738-94, who wrote an extremely influential treatise on crime and punishment in 1764. Jefferson read it in the original Italian and quoted it extensively in his literary commonplace book. Beccaria's position, in a nutshell, was that the state, the judicial system, should not seek vengeance against the malefactor. The state's only interest, he wrote, is to restore public order. The state should not seek to impose what were called sanguinary punishments. It should perhaps sequester the convicted criminal so that he can no longer do social damage, but it should not ever be vindictive. Beccaria was strongly opposed to capital punishment. He believed that the key to law and order was for the laws to be clear enough to be understood by everyone, that punishment should be swift and certain rather than vengeful. If a malefactor knows he is going to be tried quickly, using due process, and that if convicted he will certainly do the time in jail or prison, that is more likely to deter crime than the severity of the punishment. Beccaria's principle is enshrined in our Bill of Rights in the Eighth Amendment, forbidding cruel and unusual punishments. Jefferson pared down the number of capital crimes from 39 to 2 in his revision. He kept treason as a capital crime and also heinous murder. So he was not quite as enlightened as the Italian humanist. But Jefferson's Virginians were unwilling to go that far. They would not pass his bill proportioning crimes and punishment because they insisted that stealing a horse must still be a capital crime. Jefferson wisely said, "We must never attempt more than the people can bear," and he said, "The ground of liberty is to be gained by inches. We must be contented to secure what we can get from time to time, and eternally press forward for what is yet to get. It takes time to persuade men to do even what is for their own good." That was 1781, Virginia's refusal to let a convicted horse thief live. Now, 240 years later, the United States is one of only two first world nations, the U.S. and Japan, to retain the death penalty, even though we know indisputably that America's use of capital punishment has been racist in the past, and that the advent of DNA analysis has shown that a fairly large number of innocent men have been put to death for capital crimes they did not commit. The other nations that retain capital punishment include Afghanistan, Egypt, Iran, Iraq, Pakistan, Sudan, and Singapore. Really? Is that the international club to which we want the United States to belong? But alas, we are a nation with a frontier legacy, and out on the frontier, where white pioneers arrived before the formal infrastructure of law, individuals and groups took the law, if you can call it that, into their own hands, and lynched suspected criminals. Violence in America are almost historically synonymous. We are the most gun-obsessed nation in the whole world, thanks to the Founders' Second Amendment and our historical national dynamics. You need only look at the statistics of gun violence in our northern neighbor Canada, English-speaking, liberty-loving, prosperous, derived from the same British legal traditions, to see the difference between a gun-soaked culture and one operating according to other public values and traditions. When I lived out in Reno, Nevada, one of my closest friends was an extraordinary woman named Lisa Wallace. She was superb in every way, well-read, well-informed, well-spoken, immensely talented, brilliant, and life-affirming. Somehow capital punishment came up in one of our walks along the Truckee River. I said I was against the death penalty, but I could understand the desire for revenge. If my child or another loved one were killed in cold blood by some psychopath, I would want to kill him myself or see him killed. Isn't that natural and even just? I asked. Lisa stopped us in our tracks and looked me straight in the eye. Yes, of course, she said. That's exactly how you would feel, and that's how I would feel too. This is why we had an enlightenment. We'd naturally feel that, but our social contract, our civilization would step between us and that grave act of vengeance and prevent us from sinking to the same level of savagery. This was one of the great moments of my life. I immediately agreed with Lisa, but I also learned from her that afternoon the very meaning of the Enlightenment. Of course we would want revenge, but revenge doesn't bring back the person who was murdered or tortured or raped. Civilization only works if we all try to rise beyond the basest urges we are all subject to, and by killing the murderer we lower not only ourselves to that level, we also lower the hard-won civility of our national institutions. In other words, Beccaria, I think, was right. Sometimes I fantasize about going to prison. I have read a great deal of prison literature, including Walter Raleigh's History of the World, an immense study of the history of Western civilization that Raleigh wrote in the Tower of London on death row between 1603 and 1616. Think of all the reading one could do in prison, and all those push-ups and pull-ups. I very much appreciate the correspondence we get from men and women who are serving time in prison. My friend Lynn Novick in New York has done a wonderful documentary series on how the humanities and college courses in prisons can change lives. It is so very important to remind ourselves that most of the people in prison are human beings who deserve to be treated with dignity and generosity of spirit, however hard that sometimes is to contemplate. It is not quite there but for the grace of God go I, but certainly when I look hard into the mirror of my inmost life, I see darkness that would quite like to slip through the 3 iron gates of my moral consciousness. Here at the Jefferson Hour, we very much appreciate hearing from men and women behind bars. Thank you. As Jefferson wrote to his daughter Martha after she reported a scandal in the larger kin group of the family, quote, "Every human being must be viewed according to what it is good for none of us, no, not one, is perfect. And were we to love none who had imperfections, this world would be a desert for our love." I'm Clay Jenkinson. We'll see you next week for another important edition of the Thomas Jefferson Hour.
The Thomas Jefferson Hour is brought to you each week by Dakota Sky Education. The program is distributed nationally by Prairie Public. President Thomas Jefferson lived from 1743 to 1826, and this program presents his views. President Jefferson is portrayed by the award-winning humanities scholar and author Clay S. Jenkinson. To obtain a copy of this or any show for a $12 donation, please call 701-575-0727. This program is also available online at jeffersonhour.com and on Apple Podcasts. If you'd like to correspond with President Jefferson or submit a question for him to answer on the program, please visit the website at jeffersonhour.com. The Thomas Jefferson Hour is produced at Makoche Recording Studios in Bismarck, North Dakota. Bach Cello Suite No. 3 in C Major by Stephen Swinford. Thank you for listening. Please tune in again next week for another thought-provoking, historically accurate program, Through the Eyes of Thomas Jefferson.